Hello and welcome. My name's Chris Moses, and for the next 20 minutes or so, I'm going to be talking to you about managing disciplinary problems within town and parish councils. Before I start, a little bit of background as to who and what I am. I'm Managing Director of a small personnel consultancy based in the East Midlands, and we currently provide HR support to a number of county associations across England, as well as the town and parish councils. So, managing disciplinary problems, never a popular pursuit for either employees or councillors, fraught with difficulties and potentially quite damaging to the council if you get it wrong. However, the problems of poor performance, problems of misconduct cannot be ignored. To do so puts the output and performance at the council at risk. It damages its reputation with the community and ultimately results in loss of faith by the people who the council is there to serve. So they have to be addressed, but by whom? Legal position is that the full council is responsible for all employment matters, whether that's grievance and disciplinary issues, recruitment, appraisals, managing sickness. The full council has the job to do, as defined by the Local Government Act of nearly 50 years ago. However, think about this on a practical level. It would be very bizarre for all councillors to be involved in disciplinary investigations, disciplinary formal hearings, for all members to squeeze themselves into a meeting room to deal with a disciplinary hearing would not just be bizarre, but potentially unreasonable and unfair and in breach of AIRCAS guidelines. So it makes sense, and many councils do delegate this responsibility to a committee. Call it a HR committee, staffing committee, employment committee, the same body. But it has, by formal delegated resolution, assumed responsibility for dealing with disciplinary matters. Now, key points before we go on. It is essential that a council establishes the legitimacy of that committee and what it can and cannot do when dealing with discipline. It needs a formal resolution and it needs clear terms of reference to spell out what that committee's powers are and how far it can go. For example, does it carry out initial investigations into allegations of discipline or indiscipline or poor performance? Does it conduct formal disciplinary hearings? And in doing so, has it got the power to issue sanctions such as written warnings, final written warnings, or even dismissal? Failure to establish proper authority can result in some very serious legal problems. Quite simply, if a body ultimately sacks somebody for misconduct or poor performance, and they take that council to an employment tribunal to claim unfair dismissal, one of the first arguments that an employee could use is that the right people didn't do it. The people who sacked me didn't have proper authority. They weren't able to do it. Therefore, the whole dismissal was a sham. The council will have no defence and it will end up getting itself into a lot of trouble. So, these are not prescriptive, they're just examples of terms of reference that I've produced. It's up to you to produce whatever you want, but whatever you do produce needs to be clear, it needs to be straightforward, and it needs to be unambiguous. Term of reference, for example, to conduct and be responsible for all grievance and disciplinary action. The chair and the vice chair of the committee will carry out an informal investigation into any complaints, and they will report their findings to the committee. The committee then appoints 3 members who will conduct the formal disciplinary hearing with the employee, and the panel will then decide what the outcome of that disciplinary hearing will be. So, having properly allocated responsibility for managing discipline to a committee, giving it firm, clear, unambiguous terms of reference that give it the authority to do this, how does it carry out its activities? How does it do it? Well, there's a very clear-cut process for dealing with disciplinary problems, and most people will be familiar with this. Most people are familiar with the idea of starting with a written warning, moving to a final written warning, and ultimately, if they don't work, dismissal. There is one obvious way of missing out steps 2, 3, and 4 and going straight to dismissal, and that is in cases of gross misconduct. Now, it's common for us to get phone calls from councils, from chairs, from clerks to say, an employee has committed an act of gross misconduct. Tell us how we go about carrying out the disciplinary action and ultimately their dismissal. What people very rarely understand is that gross misconduct is a very, very specific allegation tied up with all sorts of legalities. So when a chair rings me and tells me that their clerk has failed to issue the agendas on time for the 6th month running, that the quality of their minutes is appalling due to numerous spelling mistakes, and that they were never told that their accounts were submitted to the external auditor late, and the council knew nothing about this until they received a financial penalty. Therefore, surely we've lost trust and confidence in our employee, and we have the right to sack this person because they've committed gross misconduct. Gross misconduct is defined as a deliberate and willful attempt by an employee to carry out a malicious act that is intended to cause harm. Obvious examples would include turning up to work drunk, deliberately not carrying out health and safety procedures, fighting, sexist harassment, bullying, intimidation. They are clear acts that the employee, when they do them, is aware that somebody's going to get hurt. Under those circumstances, a council has reasonable justification to say, we cannot allow this person to carry on working on the premises. It's too dangerous. They're going to hurt somebody, or they're going to hurt themselves, or we're going to have all our money stolen. So we are justified in taking reasonable action to remove them. It would be reasonable under the circumstances to have that person off site and remove that unacceptable risk. Similarly, to dismiss somebody without a written or a final written warning has to be done only under the circumstance where it is intolerable to allow that person back in because of the risk that they present. Okay, but even when a council has got a bona fide case, clear-cut issue of gross misconduct, if that employee is dismissed and subsequently takes the council to an employment tribunal, the threshold for the council to be able to defend themselves against a claim of unfair dismissal is quite high. A judge may accept, yes, what they did was wrong, but they will also take into account the employee's length of service, their previous disciplinary record, and any mitigating circumstances at the time when the incident happened. So an employee who has got several years in post, never been issued with any form of disciplinary action, and who can say at that time, I was under tremendous stress, we had staff off, I was being harassed by councillors, I was being put under horrendous pressure, and I just lost my cool. They may well have a good defence as far as the judge is concerned, or sorry, they may have a good claim as far as the judge is concerned, which destroys the council's defence, and they may win their claim for unfair dismissal. So making allegations of gross misconduct because the minutes were not up to scratch, the agendas were late, the budget was not published on time, whatever, doesn't cut the mustard as far as a claim of gross misconduct is concerned. It is a very technical and very specific allegation, and one that can be very difficult to defend. So let me go to the other end of that scale, from dismissal to point 1, informal counselling. Well, I said at the start, a council cannot ignore disciplinary problems. To do so will result in long-term decline, damage, and loss of faith within the community. But 90% of these problems can be dealt with by proper informal counselling. They can be nipped in the bud by a management body that has stepped in early and guides and steers an employee on the right track. Now, I'm sure you've heard of the ACAS guidelines, the ACAS Code of Practice. The purpose of that is not to set out a route map to dismissal. The purpose of ACAS guidelines is to support and help an employee who may have problems with their performance or with their conduct to get back on track and to perform to the standard that's required. And the best way to do that is tackling the problem early doors through informal counselling. So again, who does the informal meetings? Well, if we're talking about a clerk as a line manager who's concerned about the conduct or performance of an employee, it would make sense for them to do this meeting on their own, one-to-one. Nobody from the council is needed necessarily, and the employee isn't entitled to be accompanied. It's a basic premise of all line managers' jobs that they have the right and the need on occasions to call an employee into a meeting, to set out the problem, to discuss the reasons for it, and to set an improvement plan in place. That's great if it's the clerk that's responsible for managing somebody. But what happens when it's the clerk who's the problem employee? Now, there is an important legal principle to take into account here. It's called the Hillingdon Authority, and it goes back to 1986 and a judgment by the House of Lords. And what their lordships rule is that no individual councillor can take responsibility for any of the council's activities upon themselves. And that includes employments, and it includes every element of employment. So no individual councillor can discipline somebody, can carry out an appraisal, for example, can recruit people. It has to be, according to their lordships, by a committee of 2 or more elected members. So if we're talking about a disciplinary issue to do with the clerk, it's going to be dealt with by the full council as the default body. That responsibility, as I've already discussed, may be delegated to a committee, and that committee is going to allocate responsibility to at least 2, but probably 3 members to carry out an informal counselling meeting with the clerk, with the employee where the problem lies. And they need to make sure that it is done by proper resolution, because again, an employee who is called into a meeting, a clerk who is called into a meeting by 2 or 3 councillors and asked to explain themselves could accuse the council of acting without proper authorisation. Certainly those in councillors who carry this meeting out could say that they were acting totally without authorisation. Therefore, the council, who is responsible for its elected members, has acted in a way that is wholly unacceptable. So make sure that people have proper authorisation. So how do you do an informal counselling session? Well, on the face of things, it sounds fairly straightforward. You call an employee into a meeting, you explain the problem to them, and you ask them to explain themselves and what's happening. How do we need to put this right? But let me give you some clear guidance on how to do this. First thing, you need very clear reasons for holding this meeting. You need the evidence. Let me pick a simple one, for example. If it was poor punctuality, you need the dates when the employee has been late. You need the number of minutes or even hours that they've been late. So you've got hard and fast data. You've got facts. If it's the poor quality of the minutes, you're going to have those minutes in front of you and highlight the areas of concern. So what you need before you go into this meeting is to get your evidence sorted out. Make sure it's clear and make sure that there's nothing that the employee could complain about it being unfair. We've picked up on the minutes, for example. We're only going to use the minutes where there's a problem. Okay, so get your evidence sorted out. Time of day. Don't hold this meeting half an hour or 15 minutes before the employee is about to leave for home. Or similarly, don't do it during their lunch break or break times. It needs to be given proper gravitas, and it needs the employee to realise that this is serious. And to do that, you need to put time aside during the working day. Probably an hour, maybe even 2 hours, but it needs to be done in such a way that the employee isn't twitching to get away because it's getting close to home time, or they're tired because they haven't had their proper break. It also needs to be conducted somewhere that is free of interruptions and confidential. If it's the council office, are you confident that people aren't going to be walking in and out, that you're not going to get interrupted by other employees or members of the public? If it's in the community centre, again, is it confidential? Is it free from interruptions? If you're struggling, and many councils do struggle to find proper meeting facilities, why not speak to the district council or county council and ask them if they've got a meeting room that you could hire off them for half a day? That way you've got somewhere that is confidential, it's a professional environment, and you've also got a car park thrown in as well, no doubt. So find somewhere that is secure, that is confidential, and that is free of interruptions. Who's going to be there? Well, I said a few minutes ago that if this was an employee of the council and the clerk was their line manager, it would just be the two of them. As I've already alluded to, if it's the clerk who is being the subject of the meeting, then we're going to have 2 or 3 members of the council to carry out the informal meeting. The employee at this stage isn't entitled to be accompanied by their union rep or another colleague. Representation, according to Section 10 of the Employment Relations Act 1999, states that representation by a union rep or a colleague only occurs at a formal hearing. This isn't one. And I have encountered situations where councils, the very best of intentions, have allowed an employee to bring a union rep with them, thinking that it will provide them with support and help. The problem has subsequently not been resolved and ended up in an employment tribunal claim. And the whole process has come under scrutiny, including this meeting, this informal meeting. And I have heard judges say, well, if it looks like a duck and sounds like a duck, it's a duck. And in this case, you had the union rep there, you acted because of that, like it was a formal disciplinary hearing, not an informal meeting. So in that case, I'm going to assume that you did have a formal disciplinary hearing on that occasion, but you didn't follow all the necessary process. So it only needs to be the employee and whoever's representing the management. A full record needs to be kept of what is said. And what I mean by this is a written transcript. Some poor soul is going to have to write everything that is said, questions and the employee's reply. You can record it, but I'm not a big fan of recordings for 2 simple reasons. One, a recording can be edited, or people can accuse whoever of editing a recording. The second, I'm going to suggest that in the written transcript, every page of the notes is signed by the people who are there to prove that it's a true and accurate account of what was discussed. You can't sign a recording, so that introduces a fundamental difficulty, because by signing that transcript, signing the sheets of paper, you've got evidence that this meeting happened. We've got proof that who was there was there, and it's proof that they agreed to what was said during that meeting. So a detailed transcript needs to be written down. It's read back to the employee at the end of the meeting, and then it's signed. And it needs to include very clear outcome, an action plan, a plan of improvement. Remember I said that the ACAS guidelines are about support, about guiding an employee back on track. And this is where the council can prove that it's doing that. by setting out a clear improvement plan. So if it's, for example, a problem such as punctuality, the target is between now and the end of next month, we'll have no absences, no latenesses, no poor punctuality issues. If it is poor attendance, then we want to remove any absences. If there's no health problem causing an employee to take sick leave, it's just that they've had lots of bugs and viruses, then the target for that employee is massive, a 70 or 90% reduction in absenteeism over the next 6 months. So it's a very clear, it's a very specific, it's a very objective set of targets for the employee to work to. And you need to build into that review dates as well. So we'll meet again in a week or a month's time and see how you're progressing. And that is an informal meeting, an informal counselling meeting. And what that gives the council then is hard evidence that it has tried to help the employee and put their problem straight. And as I said, for 90% of people, that will work. Most people have got the common sense to realise that they're under scrutiny and they need to get their act sorted. Unfortunately, there are that smaller number who don't, who carry on and who ultimately require the attentions of a formal disciplinary hearing. Now, when we get inquiries from councils about how do we do a formal disciplinary hearing, the biggest fear for most people is the actual hearing itself, sitting in there with the employee and potentially their union rep and having to deal with the stress of that situation. Well, the formal disciplinary process occurs in 3 stages. The first one is the letter of invitation to the disciplinary hearing. The second is the hearing itself. And the third is the outcome letter. And of those 3 stages, stage 1 and stage 3 are probably the most difficult. The actual hearing itself is less so. Let me explain why. Because stage 1, the letter of invitation, and stage 2, the outcome letter, are written pieces of evidence that will come under scrutiny if this is ever challenged through the courts, through ACAS or whoever else. So you've got to get it right. And there are statutory requirements that need to be followed. Any formal disciplinary action must be preceded by a formal written invitation. And that invitation has to include details of the alleged poor performance or misconduct. It has to set out clearly what is the problem, what is the evidence of that problem, and if you've conducted an informal meeting with the employee beforehand, what explanations and improvement plans were put in place that may or partially have been achieved or may not have been achieved at all. So you need to be very specific. What a council cannot do is introduce new evidence on the day of the hearing. The employee has to have that evidence at least 2 days beforehand so that they can review it and prepare themselves for the disciplinary hearing, as well as share it with whoever's accompanying them. The letter also has to set out the date, the time, and the venue, the location of the meeting. It has to inform the employee of their right to be accompanied, either by a colleague or a trade union representative. Now, if the employee responds by saying, I cannot make that day, my union rep can't do it, or my colleague's not available, the council has a legal obligation to rearrange the date, and it has to be rearranged within 5 working days of the original date. So if a union rep, for example, states that I can't make any date next week, I'm struggling the week after, I may be able to make 5 o'clock on the Friday afternoon, 3 weeks away from now, I'm afraid that's failing to comply with the legal requirements. It has to be within 5 days, and unfortunately, it is the employer. Unfortunately for the employee, it is their responsibility to make sure that whoever's accompanying them can comply with that. So that's the letter of invitation. And what the council also needs to check is that their employee has details of their discipline procedure. It's not a bad idea to include those in the letter that goes out, along with all the other evidence. So we come now to what I've described as the less difficult bit, the meeting itself. And this is fairly straightforward. Just think beforehand, who's going to introduce the meeting? So if it's a council dealing with a clerk, so we've got 2 or 3 councillors dealing with a clerk who's been disciplined, somebody needs to chair the panel of 2 or 3 councillors, and their job is to introduce the meeting, introduce the other members of their panel, and check with the employee. They've obviously had the letter of invitation. Have they had all the information? Have they had the evidence? And then give the employee a chance to speak. Now, a disciplinary hearing is mostly a listening exercise. It's very similar to that informal counselling meeting I was talking about earlier. The employee knows what the allegation is. It was set out for them in a letter. They've seen the evidence. So having introduced the panel, having checked that the employee's got all the evidence, the council's job now is to listen. Again, some poor soul is going to have to write down the transcript. Somebody's going to have to take notes of everything that is said, ideally with numbered bullet points. The council doesn't interrupt. The disciplinary panel, the council disciplinary panel, doesn't ask questions while the employee is talking. They don't argue or take issue. They just listen. To interfere with that person's presentation can result in accusations of an unfair disciplinary hearing, because every time I tried to speak, they jumped in and started arguing with me. So, as I've said, it is a listening exercise. Notes need to be taken at the end of the meeting. If there are any questions, they can be asked then. But these questions are asked in a non-accusatory manner. You're just checking facts. So you're saying, for example, you were here on that day, you weren't off sick. You're saying, for example, you were on time that day. You don't know how we've got this record of you being late. Fine. We're not challenging. We're not saying you're wrong. What we're doing is just listening and getting your side of events. So the questions are asked. The notes are then read back. Signatures are put on the bottom of the transcript, similar to the informal counselling meeting, and then the meeting is adjourned. What you don't do is inform the employee of the outcome there and then during the hearing. ACAS guidelines are quite clear that the council has to demonstrate that it has taken time to consider all of the evidence and come to a considered opinion. And to do that, you adjourn the hearing, you send the employee away, and the panel discuss the evidence. And what their job then is to come up with an impartial opinion as to whether or not the disciplinary action should be upheld or dismissed. Which takes us to the third, and again, one of the 2 potentially more difficult aspects of the formal disciplinary process, the outcome letter. The outcome letter is obviously going to inform the employee of the decision, whether it's to give them a written warning, to give them a final written warning, or to dismiss them. And it has to go into painstaking detail as to why that decision has been made. It's better to cross-reference evidence with reasons that have been given in the hearing and reasons that the council have relied on to make their decision. So if an employee has given you one account of events, but you have evidence to contradict that, you've got to go into detail as to how that evidence does contradict, why it's been relied upon by the disciplinary panel, and therefore why the decision has been made to take this particular course of action. So very clear, very unambiguous explanation given to why the council has chosen to take this course of action. And it is important to get that right, because this could come under scrutiny at some point in the future. The letter also has to inform the employee of their right to appeal, and it also informs them of a live period. So if it's a written warning, for example, with a live period of 6 months, the employee has to realise that if they transgress again during that 6-month life period, there will be a second disciplinary investigation and possible disciplinary hearing. And next time they could go from a written warning up to a final written warning. And ultimately, if the process carries on, they could face dismissal. Okay, I said it was a popular topic dealing with disciplinary matters, and a topic that is potentially fraught with legal problems if you get it wrong. Hopefully you found that useful, and more importantly, I hope it enables you to get your disciplinary processes spot on so that you avoid the long-term problems and you keep your council out of trouble, but most importantly, you help employees to get back on track if they need that support. Thank you very much.